Hello, welcome back. This is Module 5A. This is Estates and Trusts, and we are now talking about how to construe a will. We've decided that our testator intended to make a will, had the capacity to do so, and was not under undue influence. And so now the question is, how do we determine what belongs to the will, and when can we go outside the will? So in this module, we'll talk a little bit about which pages count, and then we'll talk about how to provide some flexibility by incorporating an external document, and we'll correctly use some of the construction doctrines. There are actually three, I think, that we'll be talking about. Besides integration, we'll talk about incorporation by reference, republication by codicil, and the doctrine of independent significance. Okay, now before we go on, let's say I've got several pages. The first one might look like the beginning of a will. Can you see that? It says last will and testament. The last one probably has a signature or signatures on it, and there might be some other ones. Now, in the normal scheme of things, when we find a will, it's pretty clear what belongs to the will. The pages are numbered 1 of 6, 2 of 6, 3 of 6. Each page might be initialed. They're probably all stapled together. But sometimes it's not that clear. Sometimes we'll find some drafts, some worksheets, and all of it's all together in an envelope, but none of it's really stapled together, and it's not clear. Now, there's no golden rule about when it's clear and when it's not. The only really important thing is that if you are the lawyer, you should make it clear. All right? Make it clear what's a draft, what's a copy, what's a worksheet, and what's the actual will. Make it clear which pages belong to the actual will. When you have the testator and the witnesses sign, the signature ideally should go on a page that has some text, so that we know that those signatures are part of the will, that the will itself wasn't changed after the fact. That question of what papers go together is called integration, right? But in that context, we're talking about papers that are all right there. Okay. There's another doctrine that we'll talk about, and that's incorporation by reference. Can you, or when can you, refer to another document and kind of incorporate it into the will? We can do this, and it allows us to be a little bit flexible, but the document had to be in existence when the will is executed, and the will has to refer to it specifically, and it has to clearly identify it. And if that's the case, then we'll treat that external document as part of the will. So here's our first instance of when we can use extrinsic evidence. It's when we're incorporating an external document. Now, why would you do this? Maybe the other document already existed and you didn't want to type it again, or you didn't have an electronic version that you could incorporate into the will. Maybe we don't want the whole world to know what it says, but we do want to show everybody else the will itself. Or maybe the client just forgot to bring it. Let's look at Simon versus Grayson. Now, first thing, I know we did this in class too. When you read a wills case, make a list of the documents involved. So in this one, there was a will, a letter, and a codicil. Now, we've seen the word codicil before. The UPC says that a codicil counts as a will. It's a document that adds on to a will or partially changes a will, and it is executed exactly like a will. So in a state that recognizes holographic wills, a codicil could be handwritten. In a state like Minnesota, the codicil itself has to be executed with all the formalities, right? With a testator's signature and 2 witnesses and their signatures. Then start adding on the dates to these things so you can kind of see how they stack up in time. So here the will was dated March 25th, 1932. There was a letter July 3rd, 1933. And then the codicil was November 25th, 1933. I looked it up. It was a Saturday. So you sort of wonder about what went on during that Thanksgiving for S.M. Seligson. And I'm not sure if this was Solomon Seligson or the younger brother Selig Seligson. Anyway, the will said, there is a letter dated March 25th, 1932. And the letter said, pay $4,000 to Esther Cohn of San Francisco. Just so you can see it, yeah, that's the Golden Gate Bridge, because this was San Francisco. I couldn't find pictures of the people. The bridge actually hadn't been built yet. They were about to start building it at this time. But our problem was the letter didn't say March 25th, 1932. It had a later date. Remember, let's go back and see. Here's the dates. See, the letter was dated July 3rd, 1933. Wow, that's over a year later. Now, that doctrine of incorporation by reference says we have to have a document that's already in existence. But this one was not. Oh, so what to do? Well, don't give up, because there was a codicil that was executed after that letter. There's a journal called The Codicil, yeah, but it's an online journal or has a website. That wasn't around yet either. Anyway, what's the deal with the codicil? Why do we care? It's like magic. It republishes the will as of the date of the codicil. So it's as if you did the whole thing over on that date. And that means that now we can use incorporation by reference, because the will makes a specific reference to a letter to the executors dated March 25th, 1932. The will clearly identifies the document. Well, it was a letter that was written to the executors, and the document already exists. It certainly did by then. So 2 out of 3 is pretty good. The date's wrong here, right? Because we know that our letter is dated July 3rd, 1933. But the court says that's not a problem. The authorities in this state do not require that the informal document be identified with exact precision. It's enough that the descriptive words and extrinsic circumstances combine to produce a reasonable certainty that the document in question is the one referred to by the testator in his will. You think it was? Turns out there's a company called Exact Precision, and that's exactly what we don't have to have. So it just has to be reasonably certain. So wow, what a cool analysis. We've got incorporation by reference plus republication by codicil, plus we don't need exact precision, and we build all those together, and they kind of link together like Lego bricks to form an argument that wins the day. Okay, so now just for fun, take a look at Dexter Johnson's will on page 154. There's part of it's typed, part of it's handwritten. The handwritten part seems to modify the typed part, but we can see that the typed part was not duly executed as a will. And assuming that that the state allows holographic wills, which it did, would you allow this will to be probated? Or if you were representing one of the parties, how would you argue that it should be or shouldn't be? Post your thoughts about that on the discussion board. Just an aside, Dexter G. Johnson was an attorney in Oklahoma City, according to the case, and he actually prepared wills, and for other people, he did it right. Okay, so go ahead and turn this off. Go post something on the discussion board, and then come back and talk about independent significance. I will still be here. Okay, are you back? I'm still here. Okay, this is the last doctrine we're going to talk about here, and I guess I probably should put this in a different video.